Ready? Good morning. This is the second day of our hearings this week. We will begin with Mr. Sanders for the officers represented by the designated lawyers group, undercover officers and former managers. Mr. Sanders. Mr. Sanders, good morning.
Morning, sir. As you've just said, this is the opening statement for Tranche 2, Phase 1, on behalf of the Designated Lawyer Officer Core Participant Group. Within Tranche 2, we have 31 clients. It's 23 undercover officers, not 22, as I put in the statement by mistake. Some confusion about officers being moved between tranches. Apologies for that. 5 back office administrators at detective sergeant rank, and 3 managers at detective inspector and detective chief inspector rank. So that's our Tranche 2 cohort of clients. So I'm not going to read out all of our written opening. I won't repeat anything that's in our recap of what we say are the important propositions, contextual propositions, or our outline of the historical context. I know you've heard some of that yesterday. So I really want to address you first on just in the context of the 2 principal special branch functions that were relevant to the operation of the SDS, some contextual matters. So that's the provision of intelligence to assist the uniform branch in the policing of public order events, and secondly, the provision of intelligence to assist MI5 in the discharge of its counter-subversion function. So starting with public order in Tranche 2, it's right to start off by observing that although there were some major disorders, there were fewer large-scale disorders during Tranche 2 than there were in Tranche 1, and a general trend towards smaller-scale demonstrations and protests and direct actions. So in the Tranche 2 period, notably, there was the emergence of animal rights groups, the consequent establishment of the Animal Rights National Index as a cross-police force resource, and also the re-emergence of the far right, in particular the BNP, and a consequent rise in confrontations and conflict between the far left and the far right. So as we touched on in Tranche 1, the National Front suffered an electoral wipeout in 1979 and a dip in its popularity after that. And there was essentially a period of schism, and then the emergence of the BNP earlier on in the Tranche 2 period. And then following on from that re-emergence of the far right, there were regular times and places of confrontation, in particular Bloody Sunday marches, Remembrance Sunday marches, Brick Lane Market at the weekend, and also the site of the BNP bookshop in Welling, as well as other less regular confrontations and conflict. So although there was a trend towards smaller scale disorder, it's important also to recognise that public order remained a significant operational challenge for the Metropolitan Police to deal with during the Tranche 2 era. In terms of what we can say from available statistics, which are somewhat patchy, but we have the Commissioner's annual reports, some special branch annual reports, and the SDS annual reports, and just picking out what we can from those. And I'm not going to take you through a full review because we've set it out in writing. But between 1983 and 1992, within the Metropolitan Police District, there were on average 21 events per annum requiring the deployment of 1,000 or more officers on public order duties, and that the 21 on average ranged between 13 and 36, depending on which year you pick. We can also say that in 1983 and 1984, there were more than 160 events in both of those years, which required the deployment of more than 100 officers. And so obviously one sees there much more frequently than once a week, there were more than 100 officers deployed. And then we also have some statistics for between 1987 and 1992. During that period, there were on average 35 events per annum where the Metropolitan Police Special Operations Room was used to help control and support the public order response. And within those years, it was between 24 and 45 such events. So in our submission, it still remained a significant issue for the Metropolitan Police public order to deal with. And all the considerations we've mentioned before about avoiding over-policing, avoiding under-policing, the impact on non-public order policing were still very much live, and one can see them referred to in the Commissioner's annual reports, which we've quoted in our written opening. So reference was made yesterday to the particularly serious disorders in the Tranche 2 period. So that's the Brixton and Broadwater Farm estate riots, the poll tax riot in Trafalgar Square, the so-called Battle of Waterloo in 1992, and then the Welling disorders of 1993. I won't touch on those again, but just to pick up some other points that are also important and indicate that the public order scene remained volatile and turbulent. We've seen some suggestions of a death of a National Front supporter in 1983 called Albert Mariner. I can't help with the details of what happened in that case. There's some references to a pensioner being struck by a brick on the way to a National Front meeting, but I don't know whether that was really a far-right false flag claim or whether that was something that happened or not. But there is some suggestion of that. There were also serious disorders involving injuries to officers and members of the public and multiple arrests connected with animal rights, anti-apartheid, and student loan protests. Also, in 1986-87, the News International dispute at Wapping was a very significant public order event and public order problem from the Metropolitan Police. So we see in the Commissioner's reports and in some Hansard statements, there were 300 officers on average per day deployed to Wapping. There were 13 occasions when more than 1,000 officers had to be deployed on public order duties. And across the dispute, there were 1,462 arrests and 572 injuries to officers. So public order remained, as we say, problematic and challenging. And so the special branch's duty to assist the uniform branch deal with it by providing intelligence remained equally important and live. So turning to subversion, the statement of witness Y from MI5 confirms that MI5 extensively investigated, studied and monitored almost every group reported on by the SDS and categorized them as subversive, save for non-anarchist animal rights groups. And there may be one or two exceptions, but the overlap is clearly significant. And the evidence of witness Y about MI5 was that they clearly didn't apply or rigidly apply the Harris definition of subversion. What they looked for was a declared subversive intention or ideology, and their objectives were to maintain general awareness and visibility of the subversive scene, and also to maintain lists of members and sympathizers of subversive groups or groups being treated as subversive for vetting purposes. Witness Y also recognizes that the SDS, the intelligence it provided, saved MI5 the resources it would have needed to expend in order to obtain that intelligence itself. but that it could and would have sought that out even without the SDS. And we say that's important in terms of your consideration of the impact of the SDS, because if it's the case that without the SDS, there would still have been levels of intrusion and collection of private information and so on, that must be a material factor for you to weigh in the balance. In terms of the intelligence that the SDS did provide during Tranche 2 in relation to both public order and counter-subversion, its reports, we say, accounted for a significant proportion of the overall special branch output and a very significant proportion of its output in the public order sphere. And one can see this from the evidence that we have, again, somewhat limited evidence about numbers of reports produced and public order events covered by the SDS. We only have some figures from the early 90s. And then also overall numbers of special branch inquiries undertaken and reports produced each year, where we have some figures from the mid-80s. But one can see, comparing those round numbers, that the SDS was clearly accounting for, as we say, a significant proportion of special branches, public order and counter-subversion output. In terms of threat assessments that were produced by the special branch squads to assist A8 or TO20 as it became, again, limited information, but we can see that in 1986, Special Branch produced approximately 770 threat assessments in respect of terrorism and public order. And in 1987, 554 threat assessments in respect of terrorism and public order. Then later on in Tranche 2, we have a confirmation that in 1990, C Squad produced 45 threat assessments in respect of public order. That's obviously only C Squad, not the entirety of Special Branch. And the following year, Special Branch as a whole produced 108 threat assessments in respect of public order. And so again, one sees that this was an operationally active area for the Met, and the SDS intelligence that then fed into Special Branch was an important part of dealing with that issue. So in summary, in T2, the designated lawyer officers provided accurate, reliable, and valuable public order intelligence on far right and far left groups and confrontations between them, connections between target groups and other groups who might be supporting or influencing them, splits, mergers, front organizations and proxy organizations within target groups, animal rights group protests, direct actions, home visits, attacks on businesses, and criminal damage, the influence or the alleged influence of extremist groups on serious public order, so in particular Brixton, Broadwater Farm, and the poll tax riot, and whether or not extremists had played a part in that. DL officers also reported on the influence of far left groups, or ultra left groups as they're sometimes called, over CND, the intentions of the Green and Common Peace Camp in relation to the adjacent US military nuclear base, and a number of other matters, obviously, that you're aware of, sir, but that are being dealt with in closed. And in our submission, that, while one can criticize individual reports, the overall cumulative effect of that intelligence was very valuable for Special Branch and in turn for A8 or TO20 in the management of public order. SDS designated law officers also provided counter-subversion intelligence to and undertook tasks on behalf of MI5. And MI5 in turn regarded almost all SDS undercover officers as valuable, and it debriefed numerous designated lawyer officers at the end of their deployments. The value of this intelligence to the Special Branch squads and to MI5 is clear from the fact that, one, they both repeatedly expressed appreciation, gratitude, and praise for the intelligence, and requested more in terms of setting the intelligence requirements of the squad. There are numerous SDS intelligence reports from the T2 period where there is reference made to disorder having been avoided or contained by police action. And there are examples, which we've set out in writing, of occasions when serious disorder between the far right and the far left was avoided, particularly in the early 1990s as a result of SDS intelligence. And it appears that the so-called Battle of Waterloo could similarly have been avoided if SDS intelligence had been responded to more effectively. And so where all of this from the perspective of my client leaves us or takes us is that they are left with the conclusion in your interim report from Tranche 1, sir, that the SDS should have been closed down, and the fact that they find it impossible to reconcile that with their experience and understanding of the work they were doing, given what was being said to them at the time by the special branch squads and by colleagues in MI5. That disconnect or gap between what was being said to those within the SDS at the time and what is now being said about the value of their intelligence or the lack of value of their intelligence is, in our submission, a fundamental point for the inquiry to address. We'll come on to now just to deal with what we say about the inquiry's approach and why, in our submission, its methodology and focus is not currently geared to addressing this particular issue. And in this regard, so we say that there's an over-concentration by the inquiry on the recovery, collation, and analysis of surviving SDS documents, particularly intelligence reports, and a sidelining or disregard of other sources, the fact that many records are missing, and the fact that many matters were never committed to writing. And so what we say is that at the moment, there is an incomplete evidential basis. I appreciate the inquiries in a good position to reconstruct what individual officers did within their deployments, but in terms of the context in which they were operating, more is needed to be able to, in particular, to assess the justification for what they were doing and the value of what they were doing. In particular, it's obviously easy to take one intelligence report after another and critique it and say, well, that in and of itself doesn't appear to be justified. But the SDS was, in our submission, greater than the sum of its parts. And it's the cumulative effect and value of the intelligence and the way in which that filled the reservoir of intelligence available to the special branch squads, which is important. What we say is a flaw or deficiency in the inquiry's approach, and what we say is it's over concentration on documents and its under concentration on surrounding factors can be illustrated by reference to the T1 interim report, where from a 14-year period involving thousands of public order events, 6 threat assessments were recovered and analysed, and leading to the implied conclusion that the SDS contribution to public order policing had been overstated. In our submission, more needs to be done to gather evidence about this so that safer findings of fact can be made. The SDS was a cog in a larger machine, and in our submission, there is little point criticising one cog without considering the machine itself. Just to run through, and I know we've touched on some of these themes before, so I won't over-labour them. It continues to be the case that there are a significant number of SDS intelligence reports missing from the Tranche 2 period. one can see a general correlation between the designated lawyer officers who refer to or identify gaps in their reporting and those for whom there are significantly fewer reports than the total number of safe flat meetings that the officers would have attended. So 10 out of 23 undercover officers, designated lawyer undercover officers, for them, there is significantly fewer than reports than they would have attended safe flat meetings. And a rough kind of rule of thumb is that most officers submitted a report at each meeting. There is also, as we've addressed you on before, sir, an absence of connected materials, aside from intelligence reports, which undoubtedly did exist. So notes of telephone communications, special branch covering minute sheets dealing with the dissemination of intelligence and some of the reaction to it. As I've already touched on, special branch threat assessments, public order branch operational orders and plans, briefs and debriefs, MI5 telexes and written requests for information, which we see cross-referred to in intelligence reports, but we don't see the requests themselves, and MI5 consumer comment forms, which we do see for a handful of officers, but not for very many. There were also numerous other meetings and discussions within or involving the SDS, which were either not documented, or if notes were taken, they were not retained or have since been destroyed, or have just not been recovered. And examples of undocumented work of the SDS include meetings and discussions about intelligence requirements, targeting and tasking, safe flat meetings with the members of the squad, one-to-one meetings with individual officers, and the contents of MI5 briefs and debriefs. The relevance of all of this from our perspective, sir, and coming back to this point that my clients were being told that the work they were doing was valuable and were being asked to continue doing that work. In our submission, crucially, the inquiry needs to investigate evidence not just from the recipients of threat assessments, who wouldn't know how much of a threat assessment was derived from SDS intelligence, but could obviously speak to the value of the threat assessment. The inquiry also needs, in our submission, to investigate and hear evidence from Special Branch Squad desk officers who compiled threat assessments and who can speak to the basis for them. And in that regard, there's a number of obvious questions. To when a threat assessment was being prepared, to what extent did the desk officers refer to Special Branch registry files? And to what extent were these made up of SDS intelligence? To what extent did they rely on their own knowledge base? And to what extent was this derived from SDS intelligence? To what extent did they put questions or requests to or check things with the SDS? And how useful would the registry of files available to them have been without the information in them that was provided by the SDS? In our submission, if that exercise were done, it would become apparent that the SDS contribution to the Special Branch reservoir of knowledge about the public order scene was very significant indeed. It would also, in our submission, assist to investigate and hear evidence about the nature of Special Branch inquiries and their purpose, and also the general use and operation of the Special Branch registry. The Special Branch and MI5 vetting systems, or the way in which they interacted in relation to vetting, the general use by Special Branch and MI5 of civilian informants or covert human intelligence sources, which is obviously relevant to what the alternative would be if the SDS had been closed down. Where would the intelligence have come from? And similarly, the cost and impact of covert intelligence gathering by other means, as well as civilian informants, interception, technical surveillance, and so on. Because all of those, if one posits that the SDS could or should have been closed down, then one has to consider, well, what would what would have happened instead, and what would the impact of that have been? And finally, the likely consequences of public order policing having been conducted without the benefit of SDS intelligence, in terms of, had there been no SDS, how much additional disorder would there have been, injuries to officers and members of the public, loss and damage, and also wider impacts on what tactics and equipment the police might have had to use, the diversion of resources away from other non-public order policing, and police recruitment and retention more generally. So all of those issues, we say, surround each deployment and need to be considered and investigated in order to put an analysis of the deployments themselves in context. So I've just, in the statement, touched on two areas where examples or illustrations of areas where, in our submission, an over-concentration on documents has led to a missing of contextual matters. So the first is in relation to Home Office funding. And this arises out of your interim report for Tranche 1, where there's a reference to the SDS requiring annual authorization and funding by the Home Office. And a suggestion that the Home Office or Home Office officials could have closed the SDS or prompted the closure of the SDS. And seen set out as starkly as that is, in our submission, a startling proposition, because the executive, the Home Secretary, the Home Office, had and have no power over police operations and no power to close any police operation. And this was the case throughout the existence of the SDS, whether one looks at the Home Secretary with his Met Police Authority hat on, or whether one looks at him as the minister responsible for policing law and policy. And we've set out some references from the Blackburn and Northumbria cases about the operational independence of police, independence both of their police authorities and of the executive. The period between 1969 and 1989, where Home Office funding was specifically authorized on an annual basis, in our submission, that was simply an accounting process. One can see that from the original documents that concentrated on two budget line items, accommodation and transport, which were run through a separate accounting authorization. It is in our submission, it appears notable that these two budget line items match Section 4.3 and Section 4.4 of the Police Act 1964. And it's also important to note that before, during, and after the period 69 to 89, when that annual process was gone through, every aspect of the SDS, like every other part of Special Branch and the wider MPS, was still funded by the Home Office, because that was where it got its budget. And then indirectly behind that, it was funded by the Treasury and the taxpayer. One can see in the very early documents thought being given to whether that aspect of the funding should be run through the Waddell Committee. And then there's a discussion in late 1968 which leads to the practice. But it was clear from the evidence of the Home Office witnesses that they didn't see themselves as reviewing whether or not there should be an undercover unit. That wasn't their role. They were simply approving the financing of its unusual accommodation and transport. And one can also see that in the way in which the practice was discontinued in the late 80s, no longer necessary. But after that, it was still, the accommodation and transport was still funded by the Home Office. And I readily accept that in the correspondence, as the correspondence involved references to authorization and indeed ratification of the SDS by the Home Office did creep in. But the reality was that the Home Office had no power to approve or disapprove of the SDS, and was simply involved in underwriting one aspect of its finances. And so that's a point where we say over concentration on documents leads to a misstatement about the SDS requiring Home Office authorization. Similarly, in relation to the SDS annual reports, in our submission, that this is an area where a great deal of weight is placed on them and their analysis, when in reality, they were an annual summary of the unit, not just its operations, but of its personnel, its administration, welfare, supervision, accommodation, transport, finances, and operations. The reports were not about justifying the unit's existence, the justification from the perspective of those inside the unit. The justification came from the fact that they were being asked to provide more of the intelligence, and that the special branch squads and MI5 were requesting that they carry on. But their annual reports were simply a stock take, and not an opportunity to persuade senior managers that the unit should stay in existence. They were not in lieu of communication with senior management, which was something that happened on a daily basis within special branch. Some suggestion has been made that the lists of groups covered by the SDS were exaggerated to make it seem more impressive than it was. Those lists, when looked at fairly, which they do get longer during the 1980s, and then are completely abandoned at the beginning of the 90s, it's impossible to suggest that they were seen as vital to the continuation of the unit. They simply indicated its general scope, and when the reports are read as a whole, it's clear that there was a difference between core targets and more peripheral collateral targets, which were also covered. The SDS annual reports were in reality no different to reports produced by all manner of organisations, and we give an example of your inquiry's annual update notes. They don't go into every problem, every difficulty. There's no significance to the fact that they don't. And the important point is that the overall tone and tenor of the SDS annual reports was entirely consistent with and reflected the opinion and understanding of management and their customers about the value of SDS intelligence and the importance of its work. There's no sense in which those producing the annual reports secretly thought that the SDS wasn't doing good and valuable work, but were writing it up differently in order to keep the operation going. It was a reflection of their general views. And yes, they were proud of particular achievements, but that's commonplace in employment settings. People, when they summarize what they've been doing, are keen to emphasize, if that's what they think it is, that they've been doing good work. That's just a touch on what we say is a consequence of an over-concentration on documents and a failure thus far to expand the scope of the evidential investigation. And then just by way of conclusion, so this brings me back to the fundamental question. If SDS intelligence was not useful and valuable, why did so many of those working above and alongside the SDS keep saying that it was and keep requesting more? My clients were living in a world where MI5 was responsible for counter-subversion. It was advising government and providing training to special branch on subversion. It assessed most of the SDS target groups as subversive. It requested intelligence, provided briefs, and received debriefs. It had its own informants and sources covering the same groups and conducted out-of-hours visits. It provided photographs that it had taken for SDS undercover officers to identify. And they were working within special branch, which was responsible for assisting MI5 in the discharge of its counter-subversion functions. So from that perspective, it's entirely understandable that my clients had the belief that they did, that they were producing good work that was valuable in the public interest. It was not for them to identify or categorize subversive groups. They were simply supporting MI5. And likewise, Special Branch was responsible for assisting Uniform Branch with public order, policing, and those producing the threat assessments were requesting more SDS intelligence. Also, the Special Branch S Squad was taking photographs of SDS targets and asking undercover officers to identify them. And so it is now, from the perspective of my clients, bewildering and mystifying to hear that the intelligence that they were being asked to provide and being praised for providing was of little value. And this comes down to, in our submission, the difficulty of criticizing one cog in a machine in the abstract without looking at the machine itself. Now, we recognize, sir, that there is a mismatch between the breadth of the inquiry's terms of reference on the one hand and the limited time and resources you have available to complete the final report on the other. And that's both of those matters have been dictated by the Home Office. However, this leaves the inquiry in our submission with a choice. Either it should acknowledge these limitations and the fact that its evidential investigation has not gone wider and therefore does not allow for reliable findings about the justification for the SDS and what would have happened without it. Or the inquiry should expand its methodology and focus to cover the areas we've sought to address, emphasize in our previous openings and closing and the written opening for today, and that I have just touched on. Because leaving those who were involved with the stigma of criticism that what they were doing was unimportant or without value when everyone around them was saying the opposite at the time, in our submission is not fair on them, particularly given the impacts of this work on so many of those officers in terms of the psychological impacts, the stress, and so on. That's all I wanted to say for today. I can see on my clock it's 37 minutes, so I've just 1 minute less than Mr. Skelton, which is my main aim. Unless I can assist you any further, that's all. Thank you, sir.
You can help me with one thing. Your submissions suggest that the Home Secretary was not the police authority for the Metropolitan Police, which I have always understood to be accepted.
Yes, no, that's correct. I'm not suggesting that. I'm saying whether one looks at the role and involvement of the Home Office from the perspective of the Home Secretary with his or her police authority hat on, which obviously was then replaced when the London Assembly and the Mayor for London took over. Whether one looks at it from the police authority perspective or from just the minister responsible for policing and with residual prerogative powers in relation to keeping the peace and so on, the Home Secretary didn't have power over police operations or power to dictate what the Commissioner should or shouldn't do. And one sees, I think it's in the Northumbria case, there's an analysis of the tripartite system established under the Police Act 1964, where one has the minister responsible for regulation and oversight, the police authority responsible for funding, and the police themselves responsible for operational decisions. So apologies if that wasn't clear, but I wasn't suggesting that.
Thank you. And thank you for the brevity of your opening submissions. We may find it leaves more time for other people. Thank you.
All to the good. Thank you very much, sir.
We will now take a break. It was originally intended to be a quarter of an hour, but it may be a little longer. We will next hear from Mr. Whittam, King's Counsel, who is scheduled only to take 10 minutes. I'll rise, we will cease now to enable the transcribers to have their deserved rest, and for Mr. Whittam to take up the next position. Thank you. Good afternoon. We resume today's hearings, not, as I had anticipated, 15 minutes after Mr. Sanders stopped with Mr. Whittam, King's Counsel, but an hour and a half later with Miss Kilroy, King's Counsel. Miss Kilroy.
Thank you, sir. I'm giving opening statements on behalf of three sets of participants. First of all, Jenny, the woman known as Jenny, which is not her real name. Secondly, the category H core participants. They are 25 women who include Jenny, who were deceived into intimate sexual relationships with undercover officers, the child of one of those relationships, and a man who was deceived into a close long-term friendship. And finally, I am delivering on her behalf an opening statement prepared by a woman known as B, also not her real name, and that will conclude my openings today. Jenny was deceived first into friendship and then into intimate sexual intercourse by an SDS undercover police officer, UCO, HN78, Trevor Morris, in a relationship which lasted from 1993 to 1995. He also had a long-term intimate sexual relationship with B between 1992 to 1993. And I should clarify that the relationship which lasted from 93 to 95 was a friendship, and it concluded with an act of intimate sexual intercourse. The inquiry has already examined the inception of the SDS and its activities between 1968 and 1982. It reached the conclusion in its interim report, dated 29th of June 2023, that the SDS's methods, which included the long-term deployment of UCOs into political groups and serious intrusion into the homes, personal and political lives of many thousands of members of the public, could not be justified in the vast majority of cases. Jenny and the Cat H CPs observe that this is plainly true of the long-term deployment of Trevor Morris to spy on her and others in the Socialist Workers' Party, the SWP. As Jenny explains in her statement, neither she nor the SWP groups of which she was a part ever posed any serious threat of subversion, nor could the need to police events so as to maintain public order justify the intrusive tactics which Trevor Morris used. He entered into numerous close personal relationships with individuals in the groups he spied on. The high level of intrusion that this involved also carried a significant risk of sexual relationships, which it was the police's duty to avert. They failed to do so. Trevor Morris himself claims in the statement that he has given to the inquiry that one reason he entered into sexual relationships was to avoid suspicion as a UCO. He also states that he received no guidance or support from his managers on this issue. As the Category H CPs have explained previously in the submissions they made in their closing statement for the first tranche, the SDS's casual approach to the private lives of members of the British public, the misogyny which was rife in the Metropolitan Police Service, the SDS's lack of respect for the law, and its failure to adhere to even basic standards of management and supervision have all led directly to the mistreatment of Jenny, B, and the other women who were deceived into sexual relationships. These deep systemic problems meant that UCOs like Trevor Morris posed serious risks to the safety of women when they were deployed. I'm going to address now some aspects of Jenny's experience, which she has set out in her statement and which I'm going to summarise things that she wishes to highlight for this opening statement. She began political activism in the 1980s when she was in her teens, exercising what she considered to be her key democratic rights with a view to combating a range of evils, including nuclear war, apartheid, and gender inequality. She joined the Campaign for Nuclear Disarmament, CND, and the anti-apartheid movement. She also became involved in her university women's group, which campaigned for equal rights and safety for women, reproductive rights, and LGBT rights. This commitment to equality and anti-racism later led to her joining the SWP from 1987 to 1989, and then again from 1990 to 1994. And it also led to her involvement in the Anti-Nazi League between 1992 and 1994. Her opposition to war led to her involvement in the Stop the War movement in the early 1990s during the invasions of Iraq. In the mid-1990s, however, her work as a journalist led Jenny to reduce her involvement in political activism and protest. Jenny wishes to emphasise that her long-term commitment to political activism and protest as a student and young person was not only entirely consistent with democracy, but an essential part of the democratic constitution and health of the United Kingdom. She's never been involved in any violence, arrested, or convicted of a criminal offence. She emphasises that the SWP's objective was to build a mass movement and that it was therefore opposed to the use of violence, which was inconsistent with that goal. The Anti-Nazi League's objective was similarly to be seen and heard through exercising the right to protest, not to create public disorder. And in any event, she emphasises that she had an absolute right not to be subject to inhuman and degrading treatment. To her shock and distress, Jenny discovered in 2019 that her long-term commitment to democratic political organisations and protest had led not only to UCOs infiltrating her life and that of many thousands of others, but also that one of these police officers, Trevor Morris, had used his position of friendship with her to exploit her for sexual intercourse. Jenny had developed what she considered to be a real friendship with Morris, having first met him at a party in B's home in around 1992 to 1993. Jenny and Morris did not spend time alone together, but Jenny often ran into Trevor Morris at house parties, protests, and marches. He sought Jenny and her friends out on these occasions, speaking to her one-on-one. He made her feel special, encouraged her to confide in him, asking about her relationships and others in the SWP. She now realises that he was using this close relationship to obtain access to others and access to information. In 1994, Jenny moved, reduced her political activism, and saw Trevor Morris less. In July 1995, however, she was in central London at the time of the annual SWP conference, and she ran into Morris at a bar after the event. He showered her with warmth and affection, and after an evening of intimate conversation about family, memories, and politics, and on the strength of the friendship that they had built up, Trevor Morris deceived her into sexual intercourse just before his deployment ended, with the obvious inference that this was an opportunistic sexual encounter at the end of his deployment as an undercover officer. In 2019, Jenny discovered that Trevor Morris was a police officer on social media. She was hugely shocked and shaken to realise that someone with whom she thought she had formed a deep emotional connection, and with whom on the strength of that connection she had had sexual intercourse, was in fact a UCO. It has led her to mistrust many of those around her, and to be cautious and guarded towards those who try to befriend her now. Jenny's sense of betrayal and hurt has been aggravated by the fact that Trevor Morris has claimed in his statement that he does not recognise her real name. It is also indicative of the contemptuous attitude that he had towards the women on whom he was spying. If he is confused about who she is, it also raises the question of how many other women he had sexual intercourse with casually while undercover. Jenny would like to highlight the following issues arising from Trevor Morris's statement. His oral evidence is due at the end of this month, and she will address what emerges in more detail in her closing statement. First of all, his attitude to sexual relationships. He explains that his present attitude to the relationships is that they happened, suggesting that at the time they happened, I was, for all intents and purposes, my alter ego and not HN78. As Jenny has pointed out in her evidence, it was him, the undercover police officer, who formed sexual relationships with the women on whom he was spying and with her. It was not his alter ego, and he should take full responsibility for that. It is disturbing that he is still unable to do so. Secondly, she would like to highlight, as I've already intimated, that the one-off incident that he describes with the other woman, in other words, her, happened right at the end of his deployment, and that he used his story, his exfiltration story, the account that he was given and had devised in order to extract himself from his undercover role, as a way of deceiving her into having sexual intercourse. He said that he was leaving the United Kingdom to return to Germany to reunite with his estranged wife and family, and he says that that led to us spending one night together. So in other words, he used his story to obtain an opportunistic occasion of sexual intercourse. The second aspect of his evidence that Jenny would like to highlight for exploration in this phase of Tranche 2, but also later, is the knowledge of management. Trevor Morris has said that he did not inform his managers of his relationships with either Jenny or B, but Morris's relationship with B was common knowledge in the North and East London branches of the SWP, and it's hard to believe that other UCOs were not aware of it. Thirdly, the lack of any safeguards. Trevor Morris has admitted in his statement that a civilian would occasionally accompany him to events as a cover partner. He has stated that he explained the risks and implications of this civilian undertaking this role, telling her that he was undercover investigating a drugs crime. He has justified this decision on the basis that he thought it was appropriate to enter into this type of arrangement with a civilian because he had no other option as a result of trying to avoid someone else in the SWP entering into a relationship with him. The idea that undercover officers would be freelancing with their own contacts, not other police officers, without arranging this with managers or anyone else in the police force, using them as a kind of subcontracted undercover officer, members of the public, is extraordinary, and this is something that should be investigated, both how widespread it was and how on earth it came to occur. Fourthly, lack of training. Trevor Morris explains that he did not receive any training for the role of undercover officer before being deployed. He has also stated that he did not receive training in his police service prior to joining the SDS, which was particularly relevant or helpful in his work. While he did receive some training for his role in Special Branch, that did not include conduct and ethics, sex discrimination, race discrimination, maintaining public order, other than basic training, or countering subversion. Again, this highlights an aspect of the establishment and running of the SDS, which is wholly unsatisfactory. Fifthly, highlighting from Trevor Morris's evidence, the culture within the SDS and how what he did was part of a wider culture. Trevor Morris was approached and encouraged to join the SDS, as he reveals in his statement, by Bob Lambert. Bob Lambert himself entered into a number of sexual relationships with women and fathered a child. His interactions with Trevor Morris are important to understanding the culture which led to Trevor Morris deceiving Jenny and B. And it is also remarkable in this regard in relation to culture that even though Trevor Morris knows that UCOs John Dines and Jim Boyling formed intimate relationships with women on whom they were spying, he describes them as good UCOs. That is the way in which men who abused women in their role are viewed by other UCOs, and it is symptomatic of a deeply problematic culture. Sixthly, the attitude to left-wing movements. Trevor Morris has explained his motivation for joining the SDS on the basis that the left wing, as he put it, wanted to undermine the fabric of the UK by causing fissures in society. He doesn't explain how he reaches this broad-ranging conclusion, and Jenny wishes to make clear she does not accept any of his characterisations of the SWP in this way or as a subversive organisation. He has not properly explained it, and she disputes his account of what occurred at the Welling demonstration. And she highlights that contrary to what Trevor Morris has asserted about the SWS, the SDS briefing document of the 5th of April 1993 concludes that SWP leaders may provoke others present into action, but generally the organisation does not pose a serious threat to public order. So in conclusion on Jenny's opening, Jenny considers it is clear that Trevor Morris's long-term undercover deployment should never have occurred at all, and that nothing like it should ever occur again. His exploitation of her and other women, including B, and the fact that he was able to operate without any effective supervision is symptomatic of deep misogyny within the police force and a culture of casual contempt for members of the public and the law. She hopes that the outcome of this inquiry will ensure that members of the public who decide to join political groups or exercise their democratic rights are not exposed to this type of intrusion or abuse ever again. Finally, Jenny wishes to emphasise that she has many unanswered questions about the extent of the surveillance of her, what information was gathered about her, and how that could have impacted her relationships and her career. She has seen no documents that relate to her other than Trevor Morris's statement and a short extract of HN 29's statement. It's important to recognise that that knowledge vacuum itself causes her significant and continuing emotional distress. She has been asked to and has shared very intimate and personal information as part of the inquiry process, but she has so far received no answers as to why Trevor Morris targeted and befriended her and later had sexual intercourse with her, and she hopes that answers to these questions will emerge in the course of the inquiry. I'm now going to turn to make some short observations on behalf of the Category H core participants. I want to emphasise at the outset that the Category H core participants will give their main opening statement addressing all the themes that are relevant to Tranche 2 at the commencement of Phase 2 in October 2024. So what I am doing now is simply making some short observations in advance. The Category H core participants wish to highlight key features of the process to date, which have caused them significant concern and difficulty in preparing their evidence and have, they say, impeded them in assisting the inquiry in discharging its terms of reference. First of all, there have been, and this is not in dispute, extensive delays to the disclosure made to the Category H core participants. Significant documents have only been disclosed in 2024, and in some cases, significant documents have arrived after Rule 9 requests for witness evidence from these core participants were received. Some relevant Tranche 2 disclosure still remains outstanding, and other disclosure that has now been made has been made a year behind schedule. This delay has led to Category H core participants being unable to provide their statements in time, and it has also restricted them from fully and effectively participating in the inquiry because until they submit their statements, they have been denied access to the hearing bundle. Now that prohibition has been modified recently, but Category H core participants who do access the bundle without submitting their statements have been warned by the inquiry that their statements may be prejudiced, the credibility of them may be prejudiced, and some have accordingly chosen to wait until their statements are finalised. This has had the consequence that whereas in the past many Category H core participants have worked collectively on the Rule 10 process, but they are prevented from doing that now because some of them don't have access to the hearing bundle. And they wish to say that this is not only unfair, but also counterproductive for the inquiry. They emphasise that they have much to contribute in terms of examining the truth and reliability of the evidence of UCOs. They do feel that they and their evidence have been treated with disregard, despite the fact that they are only involved in the inquiry because of the emotional and sexual abuse that they suffered at the hands of the police, and despite the fact that they are already traumatised. The extreme difficulties they have faced in engaging with the inquiry have caused them considerable additional distress, and they express the strong hope and expectation that in the remainder of Tranche 2 and onwards, they will have an adequate opportunity to assist the inquiry properly in discharging its terms of reference. It feels particularly unfair to them that having waited up to 9 years for disclosure of documents, there has then been insufficient time for them to be able to properly analyse them, and that they have also been placed under enormous time pressure to prepare both privacy applications and their statements. The second point that they wish to emphasise in relation, which relates to those privacy applications, there has been considerable disparity in the time allowed by the inquiry for its consideration of the police and state applications for privacy and secrecy, and by comparison that the time allowed for Cat H CPs. Cat H CPs have been expected to make detailed privacy applications before disclosure to them is complete, before they have had fully informed legal advice, and despite the inquiry being warned in advance that they needed additional time to prepare because of the pre-existing trauma caused by the officer's actions. The length of time that it has taken for police privacy applications to be concluded has meant that there has been insufficient time to deal with Category H CP's privacy concerns ahead of publication of the hearing bundle. And as I've already highlighted, this is particularly oppressive and re-traumatising for women who've already endured such serious violation of their privacy as a consequence of being deceived into intimate relationships by state agents. Thirdly, in relation to Tranche 3, which is coming, the Category H core participants note with concern that there have been changes in methodology being applied by the inquiry going forward, and they do urge a reappraisal of this approach. It appears from recent correspondence with the inquiry's legal team that the pressure to conclude this inquiry by 2026 may lead to the exclusion of crucial evidence about spying on political groups. And in this regard, they are concerned about the refusal to change non-state core participant characterizations, the apparent refusal. This appears to be a direct response to requests by Category H core participants to be recognised as political, environmental and social activists as well, and not only as women who had an intimate relationship with a UCO. They say that this effectively reduces them to their intimate and sexual relationships, their involvement in this inquiry, ignoring the wider interference with their political organising. They consider it essential that they are able to challenge the context of political persecution in which their abuses were allowed to occur. Many of them were active in some of the most significant political and protest groups and were named as targets for deployments by both the SDS and later the National Public Order Information Unit. And these deployments spanned many years. Under the current inquiry's current approach to Tranche 3, however, much of the evidence about these political and protest groups will not be disclosed to them, because the inquiry is refusing to recognise the groups as separate entities for the purposes of group disclosure and group statements. So they urge the inquiry to reconsider this approach and to designate some of the groups, the most important ones, as separate core participant entities so that disclosure can be made to them. Finally, sir, I would like to make a few observations, short observations about the statements made by other state participants in this inquiry. The Category H core participants note and welcome the Commissioner for the Metropolitan Police's recognition that the actions of undercover officers in entering into sexual relationships with members of the public, and the fact that this occurred for so long without being prevented by senior management, is the result of a culture of sexism and misogyny. And they welcome the Commissioner's commitment to eradicating that culture within the police force. They also note and welcome the Commissioner's acceptance that the professed ignorance of sexual relationships by managers in Tranche 2 is not plausible, and that some of them did know and did suspect sexual relationships. This is an important recognition of the reality of what has gone on. It has been Category H, the position of the Category H core participants from the start that it was inconceivable that managers did not know or suspect that relationships were occurring. And the Category H core participants consider it essential that despite this acceptance by the Commissioner of the reality of the situation, that there is still a careful exploration of how it managed to occur, that managers knew or suspected what was going on for so long and failed to take any action to prevent it over so many years. And indeed, as the Commissioner himself recognises, many of these managers went on to positions, senior positions in the police force, and they still did nothing about it. That is reflective of the culture of sexism and misogyny, which is so problematic in the police. That's the first observation. The second observation relates to lawlessness. Although the Commissioner accepts the culture of sexism and misogyny, there is still not an adequate understanding of the relationship between the attitude of the police in general and undercover units in particular, their attitude towards lawlessness, in particular trespass, and what happened to these women. Under the common law, the law of trespass is a critical tool in protecting members of the public from the executive excesses, and understanding how important that law is critical to protecting the public going forward. I will address this in more detail, and I have addressed it already in submissions that were made at the end of Tranche 1. But the continuing failure to recognise how significant it is when a police officer crosses the threshold of a member of the public's private and intimate home is a concern. It is necessary to recognise that the rule is that you do not do that without clear and explicit authority. And until that is properly understood, members of the public are in danger. The final point that I wish to highlight, which is absent from the Commissioner's opening statement and that of the designated lawyers, is a recognition of how strictly justified the undercover tactic must always be. Spying is risky. In any situation, it creates risks, both because of the secrecy that is involved, which means that abuses are less likely to come to light, but also because of the level of intrusion into private lives. And that is why it must only be used as a last resort when there is no other method of policing or any other type of intrusive state action that can achieve the same goal. Strictly justified and last resort. The Category H call participants wish to make clear that it is their hope that the inquiry will make that recommendation at the end of these, at the end of all tranches, at the end of the inquiry process, that the police understand and recognise how strictly justified the use of the undercover tactic must be. That concludes my oral statement on initial observations on behalf of the Category H call participants. I'm now going to deliver the opening statement that has been prepared by B. This is, I emphasise, her opening statement. Before I start, I want to highlight that she adopts the statement that I've just given on behalf of Category H and also supports that made by Jenny, who was of course deceived by the same officer. She wishes to preface her statement with the following. The inquiry has accepted that in principle it was wrong for undercover officers to have intimate relationships with women as human shields to lend those officers credibility while spying on the organisations to which they belonged. Of course, it was wrong on so many levels. In B's case, there were also 4 very young children involved. Her own children, aged 1 and 3, at the start of her relationship with Morris, and his own small children, who were deprived of their father while he was undercover. Along with Category H, B's hope is that the outcome of this inquiry will ensure that members of the public who decide to join political groups or exercise their democratic rights are not exposed to this type of intrusion or abuse ever again. B's opening statement. I was in a relationship with HN 78 from 1992 to 3, unknowingly providing cover for him as he spied on the SWP and other social justice campaigns. I am involved in this inquiry through no fault of my own. It is because the Metropolitan Police employed officers to spy on groups campaigning for social justice by infiltrating them full-time, and also sanctioned their deceitful relationships, including sexual ones, with a number of women they befriended as a cover. The chair of the inquiry has, following the first tranche of evidence, 1968 to 1982, come to the firm conclusion that the end did not justify the means. And unfortunately, those means have been very damaging to many lives. Those of the women they had sexual relationships with, those they befriended and betrayed, those whose valiant campaigns were undermined, for example, the families of people campaigning for truth and justice after their relatives were killed by the police or racists, and also the mental health of the police officers used as spies and their families who were also betrayed. Bobby, which is the name that she knew Trevor Morris by, claims in his statement that SWP was a subversive organisation, despite some special branch reports suggesting that the SWP did not pose a serious threat to public order. I don't regard my beliefs as subversive, but what the police did to me definitely was. I believe Bobby made this claim up in order to try to justify continuing spying on the organisation, and he is lying about the SWP's aims and tactics. I now want to address Welling. I am particularly enraged by the part that Bobby played in the demonstration against the British National Party headquarters in Welling in 1993, which ended with many people being severely injured through police entrapment tactics. I would like to focus my opening statement on this event because it seems to me an example of why the tactics of the undercover police officers in the SDS were not only pointless, intrusive and immoral, but were also dangerous, counterproductive and shameful. I am appalled that Bobby should try to take credit for the disaster which happened on this day, as if proud of the part the police played following false intelligence. Bobby claims that on the 16th of October 1993, there was an SWP plot to burn down the BNP headquarters, which is absolutely against anything the SWP would do. This is a preposterous allegation. From what has now been disclosed in the inquiry, as I understand it, there is no supporting evidence for his claim that I have seen other than his own assertions. There is no corroboration, no testimony from others, no documents or footage to support his claim that there was a separate split-off group of the SWP on the 16th of October 93. I strongly believe that there is no support for it because he has made it up. The SWP, alongside the Anti-Nazi League and other organisations, had spent months building for the protest at Welling to protest in the biggest numbers to close down the BNP headquarters. The reason 60,000 people attended on the 16th of October 93 was due to consistent organised activity to get as many coaches to the London suburb because of what had been happening in the area, with racist attacks leading to racist murders. This activity included consistent leafleting outside stations and in communities, public areas, meetings, and outside stations across the country. This was in the days before mobile phones. The BNP bookshop, opened in 1989, was acting as a headquarters for the fascist BNP in the area. Richard Edmonds lived upstairs and had told the Guardian's Duncan Campbell, "We, the BNP, are 100% racist." In 1993, racist incidents increased in South East London by 300%. Black and Asian youth were victim to racist attacks in the area in that period, which led to a series of racist murders, including Roland Adams, Rohit Duggal, and Stephen Lawrence. The reason there were such numbers at the Welling protest is because everyone identified the rise of these racist murders with the presence of the BNP. The policing at Welling was terrifying. It is difficult to see how this inquiry can make findings on the scant information it has before it, which has only recently been disclosed. As far as I can see, there is no documentation from the police officers in charge of the policing of the Welling demonstration. Even within the small number of documents disclosed by the inquiry relating to Welling, there is reference to serious criticism of the policing at Welling. A Liberty report is referred to which, quote, condemns the police violence and the attack on Chief Steward Julie Waterson, who was truncheoned by police officers whilst appearing for calm through a megaphone. The report also states that according to the Association of Chief Police Officers' Secret Police or Public Order Manual, aggressive policing policies form a significant part of formal police training for demonstrations and other assemblies. This was clearly in evidence at Welling, where police closed all routes of the demonstration and never used their PA system to direct demonstrators. over 60 demonstrators received truncheon injuries, whilst the police made relatively few arrests. And may I say, in my capacity as counsel, by parenthesis here, the Police in Action report, which I believe will be put on the EPIC system, and which the Category HCPs referred to in their closing submissions for Tranche 1, endorses this account of how the police went about their public order duties, because it explicitly records that the police felt that they were relieved of some of the obligations in terms of avoiding violence with members of the public when policing public order, and that they used more violence on those occasions than they otherwise would. They were freed from the restraints that ordinarily applied. And so it is important, in my respectful submission, that evidence like this is considered alongside the contemporaneous Police in Action report, which supports it. So turning back to B's opening statement in her own words, an article which appears to be written in Time Out in 1994, full date unknown, by the Guardian journalist Vikram Dodd and Julian Kossoff, which states, an internal Metropolitan Police document which reveals that flawed police tactics were largely responsible for the riot at an anti-racist march in Welling last year, is set to reopen the debate about police strategy when dealing with large, volatile crowds. The debriefing document, which emerged during the recent trial of a man accused of involvement in the riot, indicates that much of the violence could have been avoided if different tactics had been used. This supports the view of the march organisers, who have always argued that the police decision to cut off the only escape route sparked off the trouble which left 70 people, including 12 officers, injured. The inquiry needs to be aware of the wider context, which has since been confirmed concerning the policing of the Welling protest. First, a few days before the protest, the Metropolitan Police served on the organisers of the protest a Section 12 public order notice. This ordered that they follow a redirect of the route of the march, which intended to go past the BNP bookshop in the opposite direction down Lodge Hill. Second, on the day the police closed off all 3 roads at a crossroads that the march travelled to, including Lodge Hill, which created a complete block with no exit for the demonstration. The police in charge denied claims that they have closed off all exits, including Lodge Hill. But a month later, BBC's World in Action showed BBC footage that confirmed they had done exactly that. The police had therefore made it impossible for the protesters to follow the police's Section 12 notice by closing off those 3 roads. Thirdly, there were 83 police horses present on the day. Police horses charged the protest. The enormous protest had no means of exit, as Lodge Hill had been closed off by the police. The horse charges were in breach of the secret public order manual, which required that the chief officer must be certain there is ample space into which the crowd may disperse. Fourthly, the officers in charge on the day were Commissioner Paul Condon, Deputy Assistant Commander David Osland, and Commander Hugh Blenkin. All 3 officers were also involved in the Stephen Lawrence case, the very case that had inspired thousands of people to protest at Welling. Blenkin and Osland were involved in the instigation of the review into the police investigation into Stephen Lawrence, which was carried out by Detective Chief Superintendent John Barker. With Condon, they signed off on Barker's review, which concluded that the Lawrence murder investigation had progressed satisfactorily and all lines of inquiry correctly pursued, and was subsequently criticised by the Macpherson inquiry. Osland is referenced 165 times in the Macpherson report, including with reference to a memo he wrote stating, "Our patience is wearing thin with the Lawrences," which was written just a month before the Welling protest. Macpherson held Osland responsible for the breakdown of relationships with the Lawrence family and for holding back the Barker review from the Lawrence family. Fifthly, the police were operating at Welling under a secret public order manual dating back from 1983, where the then Home Secretary, William Whitelaw, had privately instigated and authorised paramilitary powers for the police. These were derived from Hong Kong. The only people who had access to the manual were ACPO officers, i.e. officers of Blenkin's rank upwards. Even the rank and file of the police did not know of the existence of the manual. Sixthly, neither the police or the Home Office have admitted that the Home Office authorised these secret powers. Parliament knew nothing about the manual or the SDS. Without exploring this history, the inquiry will not be able to properly understand the policing that took place on the 16th of October 1993, nor assess the credibility of the statements made at the time from the officers in charge of policing that day. Seventhly and finally, the self-serving statement of Bobby is not supported by independent evidence, nor what we now know happened at Welling. The current mayor, Sadiq Khan, in his previous role as a respected civil rights lawyer, represented Julie Waterson, one of the organisers of the Welling protest, and obtained damages from the police. In 2000, on obtaining damages, he said, "The police on the day acted in an arbitrary, oppressive and unconstitutional manner. The payment of these damages and legal costs is a vindication to Ms. Waterson and all the innocent demonstrators who were injured on this day due to the manner in which this demonstration was policed." Bobby refers to receiving a commendation in 2003, nearly 10 years after Welling, for the intelligence, quote, he provided on Welling. This is bizarre, given that the information he provided, I believe to be false. I am proud that so many people attended Welling to demand the closure of the BNP bookshop. A year later, it was finally closed down by the council. The SWP and Anti-Nazi League, alongside other organisations, played their part in that, and the area became a much safer place for Black and Asian people as a result. All that was despite the policing on the day and the policing of the Stephen Lawrence murder investigation, which has been subject to extensive criticism over decades and has still left the Lawrence family with injustice. I turn now to unjustified surveillance and the question of whether it was justified for Bobby to survey me. That the SWP did not use public disorder as a political tactic. It is an organisation dedicated to mass mobilisation, which cannot be achieved through illegal activity, as this would alienate most people from involvement. The aim is to build a mass working class movement to support workers' rights and to challenge the system where wealth making for the few is the dominant ideology. It is entirely open, welcoming, legal and authentic. I believe that the false intelligence given to the police, which Bobby believes to have been his, led to the violence perpetrated on that day. That is the Welling Day, as anti-racist protesters were hemmed in on all sides and beaten by officers. I was there and I saw what happened. Furthermore, the only person I know who went weaponised to any demonstration was Bobby himself, who I seem to remember was always armed with a sharp umbrella, which I know at least one comrade had pulled him up about. In short, I believe Bobby acted as an agent provocateur to try to justify his part in spying on an organisation which had no secrets due to some misplaced belief that he was trying to do the best for his country, and also a sense of grandiosity, which is clear in his statement. It is worth pointing out the nature of some of the specific intelligence reports associated with Bobby to show the extent of police intrusion into lawful democratic activity and the misuse of public funds. They include reporting on a public meeting seeking justice for a miscarriage of justice case, the Tottenham 3, where the police were subject to criticism. A party to celebrate an SWP's 70th birthday. A leaflet that Liberty wanted to set up a branch in Hackney. The death of Dr. David Widgery, a homosexual member of the SWP who had returned from abroad after what Bobby described as a lover's tiff. That someone's ex-wife was an alcoholic towards the end of their marriage. This was one of the causes of the breakup of the marriage. a report that raises police bias against the decidedly effective intervention of the Anti-Nazi League in the BNP losing its seat on Tower Hamlets Council. The report gave the response, the immediate prospect as far as public order is concerned looks problematic. The question remains as to where the information that Bobby was compiling over years on an organisation openly fighting for socialism and amongst other things racism was being sent. The SDS presumably was set up to monitor demonstrations, but in fact they were acting like some sort of Stasi, compiling intelligence on many individuals. What happened to all that information? Also, were the police also using informants? Socialists are people who want a fairer, more equal and more just society. We are motivated by respect for human beings and our environment. Any society that feels threatened by these motivations should look closely at what they are defending, not give free rein to its agents to sabotage the very people and organisations striving for a fairer society, not give carte blanche for the exploitation and vilification of those who give their time and concern to create a better community. Bobby attempts to portray his subterfuge as some kind of heroism, despite admitting that he was conflicted at times, though not for the obvious reason that as a black man he was defending actual organised racist groups, the BNP, while attempting to undermine an avowedly anti-racist organisation. In reality, what Bobby did as an agent of the SDS was pointless and counterproductive in terms of improving our society, and personally damaging to me and his own family and others who were hurt as a byproduct of his state-sanctioned agitation. I refer particularly to Welling. My main unhappiness, though, is with the people who produced the policy enabling undercover surveillance of us and the politicians so desperate to retain the established hierarchies that it was felt necessary to undermine us in whatever way they felt was necessary. Bobby was a willing pawn in this game. So that concludes B's opening statement in her own words and on her, which I have read on her behalf. Unless there's anything else that I can assist you with, that concludes my openings.
Thank you very much. May I correct one minor statement of fact that you made very early in your opening? Coming from me, who has a far from flawless record in predicting what is going to happen in the inquiry, it may seem curious, but Trevor Morris is going to give evidence not at the end of July, as you said, but on the 1st and 2nd of August.
I'm grateful for that. I think it's B and Jenny who are giving evidence on the 29th of July.
They are indeed, and then there will be a gap, and then they will be followed on the 1st and 2nd of August by Trevor Morris.
Yes, I apologise for that error.
Not at all. If those are the only errors we all make, life would be much more straightforward. Thank you. We will now adjourn until 2 o'clock, when we will resume with Mr. Scobie, King's Counsel, who will take, I understand, about an hour and a quarter from 2 o'clock onwards. Thank you all.